Okay. Good morning, everyone. And Gopa, I'm going to answer your question first. I'm sharing your screen.
Okay.
Is it visible? Is it visible?
Yes, sir.
Okay. See, 134 talks about where any country is specified by the central government. In this, we have by notification. See, that means unless India notifies that there is this country which is not going to reciprocate, there is no country where we are saying we will not be reciprocating. So as a logic, you can understand, I am reciprocating with every country unless I am not notifying that this man or this country I'm not going to deal with.
Okay.
Okay, so provision is that gives me a power. Now, when I say there is no notification, that is as per our search, and I have not found any notification to that effect. So that is what the country has, India has not given a notification till date. Hence, it is reciprocating with everyone, and everyone is reciprocating with the day will be eliminated against. India has the right under this 134 to give a notification and say that that particular country's national will not have the reciprocity, will not have the benefit of that reciprocity provision.
Okay, sir. Sir, actually, I am asking that. So sometimes some question I saw that some countries they are like Pakistan. They are not under PCT. They are not under that Paris Convention. So if any person wants to file in India, so then what section I should mention there? Like according to what section they can come and file patent here?
First thing, not about Pakistan, Bangladesh. First thing is there are three ways in which you can appear. First is as a convention country, you come and try to file it. Second is you opt for PCT route. That is, you file a PCT application in this. Now, when I say international arrangement, then I'm saying that international arrangement is for what? For saving your priority.
Yes.
Right. For example, there can be a situation for Indians also that they want to file only in US and they don't want to protect their patent in India. There can be a situation. If that is the situation, they can directly approach the US, right? They don't have to file anything in India. So they are not claiming any priority in India on the basis of Indian application. If they are not claiming any priority in India, then it is fine. They can directly approach as a normal applicant. There is no priority required. Convention countries and this Paris Convention, convention countries means generally Paris Convention countries. So in Paris Convention, what we are saying? We are saying there will be a base application whose priority you can claim. Yes. Because our novelty criteria is absolute. Your own application will hinder your patent prosecution here. We will consider that is not novel because that has already been patented. Yes. Or applied for. Right? So the problem here is we decided, everyone, the countries decided in convention as well as PCT arrangement in both. The thing is that we are deciding that how to preserve the priority. In one jurisdiction, if an application has been filed, what procedure should be followed that priority of that application is preserved when I am applying for in another jurisdiction. Hence, my own application does not hinder my patenting of my own invention.
Yes, sir.
So it's not about Pakistan and other thing. They can always come with a normal route. They don't have to claim the priority. That's
Okay, 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 sir. Thank you.
okay. So we have understood. Recap is simple. Who can be the applicant? Who can be the applicant? Sorry, it's wrong. And I think section 7 is not section 6, no?
Yes,
I have written wrong. Yeah,
section 6.
it's a section 6.
Mm.
See, remember section 6 talks about who can be applicant, and
Yes.
section 6 what we have studied, that true and first inventor has the right, and then from true and first inventor other people can get right. If you are an assignee, you can get the right. Then if you are a
Legal
legal
representative.
representative of a deceased true and first inventor, you have the right. First we talk about these three. Then we talked about 2.1 section 2.1 AB. It talks about the definition of assignee. Please remember. You can remember it like assignee of B, AB, whatever, if it works with you. Then what I'm trying to talk about assignee is that assignee of assignee or assignee of a legal representative will also be considered as assignee. So what I'm saying is protection of assignee, I'm extending to the next level also under section 2.1 AB.
And sir, what is the last line, sir? Reference to that last, like in that definition, reference to the assignee, that another one line is there, sir. So what is that mean, sir? In section 2AB.
Let me open that. That makes things easier.
And references to the assignee of any person include
AB.
references to the assignee of the legal what is that mean, sir?
First it says assignee of assignee and the legal representative. And it includes references to assignee of legal representative assignee. What they are saying is, if I am referring anywhere that an assignee can file in this act, if I'm referring that assignee, to understand that assignee will include the reference to assignee of legal representative or assignee of that person. If I'm saying assignee, please understand that it is not only assignee, but assignee of assignee also. Assignee of legal representative also. That's what he's talking about.
Okay, okay, okay. So,
If
sir,
I'm just
references means proof of rights, sir?
No, references means, see, in this act, I'm going to use again, referring to particular, references is that whenever I'm saying, for example, I say references to section should mean the section of this act. References to schedule should mean schedule of this act. That means don't go for other places, look into this one. You might see this, it says that in this act, unless the context otherwise requires, any reference to the controller shall be construed as including a reference to any officer discharging the function of controller in pursuance of section 73. What he is saying, wherever I'm saying controller, he might not be controller, but he is discharging that function in place of controllers. Controller has delegated something. So it should not be considered that he was not controller, he was someone else. Any officer discharging should be understood as a controller. That's what.
Okay. Sir, my next question is that legal representative of true and first inventor,
Yes.
he will not be considered as a, here, applicant.
Why not?
But it is not mentioned in that BR Act, in the Patent Act. They are
Where it is not
telling,
been. See,
sir, according to section 6, only the true and first inventor they mention. Legal representative of deceased person they mention. If the question comes there like legal representative of true and first inventor, he or she will be considered as applicant or not. So what it will be need to give answer.
where are you confused? First thing, who has the right to apply? First thing, Who has the right to apply?
True and first inventor.
True and first inventor. If
Yes.
true and first inventor is there, he is existing, either he can apply on his own, भाई आप अपनी application खुद ही file करो. Like second what is the second point? Second point is you transfer this right to someone. He becomes your assignee.
Yes.
He can file.
Yes.
Legal representative means how can your son or anybody else can file when you are there and you have not assigned. There is only one condition, that the inventor is no more. Then only legal representative will get the right. You know?
Okay.
See what is talking about. By the legal representative of any deceased person who immediately before his death was entitled to make some. This who is defining deceased person. The legal representative of a true first inventor who died.
Okay.
Otherwise, he is existing, and if he is existing, there are only two ways: either he files or his assignee files.
But sir, if he has some disease, he cannot sign, like that kind of thing happens.
See, even if you are there, you cannot sign. You can always. You are not even signing everywhere. Wait. The first thing is simple. There is always a patent agent who is doing it on your behalf. You are authorizing a patent agent to do everything. First thing. Yeah. Second thing, if you are not there, but you are alive, you can assign, right?
Yes. Okay. 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 I got it. Thank you, sir.
This is okay. So 6, and then we were talking about how to remember 21A B. 21AB, right? 21AB means assignee. You can always remember assignee of B. Right. So if B is assignee of A, it will also be considered as assignee. That's what assignee definition is. Assignee is also an assignee. Legal representative of a deceased assignee is also, he also can assign, and his assignee will also be considered as assignee. The references of assignee, and then I think I've cleared the references here also. So remember this only. Then go for second part. 21Y. So 21Y is true and first inventor, and definition device who is not the true and first inventor. True and first inventor does not include either the first importer or person to whom invention is first communicated. The first importer and the first recipient of the communication are not true and first inventor. That's it. So they cannot become an applicant. Who cannot be an applicant? Again, if you are a national of a notified non-reciprocating country, you cannot be an applicant. Then any patent official who is at present is in employment of patent office cannot go for patent application, because 75 bars them that they cannot have any interest in patent or invention. However, there is an exception that they can get that right through inheritance or bequest. Now comes types of applicant. What is the types of applicant is? That we have decided natural person. Natural person is also defined in Patent Act. See. From here. Okay, not here. I have read. I will just refer it to you. Okay. So natural person are the individuals or any other person who is not a natural person. And then a startup SME, that is small entity. If I'm talking a small entity, then we go for MSME Act. If you are registered under that, you are below, you are not, you do not qualify as a, if you qualify as a small, micro or medium there, then you are a small industry and you can get the benefit of that. Startup is, as we have decided that not more 10 years of incorporation is not even, and you are a private limited company or a partnership firm or an LLP, you can go for a registration as a startup. If you are registered as a startup, you have a startup certificate by DIPP, or I think now it is called DPIIT. ITT, so internal trade and
DPIIT.
so that is DPIIT. Then this is startups. Then go for educational institution. Educational institution, you can be either a statutory university, that is you have been established under some act, or you are authorized or recognized by any competent authority of the government for this purpose. This is the simple understanding of educational institution. This is what we have done. Now, see, residents can have, for example, an Indian resident is here. He may not want to apply for patent in India. If that is the case, what will happen? If there can be a case where Indian resident, I'm resident in India, but I want to apply in foreign jurisdiction also, how can I do that? The first thing it talks about, section 39 will deal with this, and it talks about simple. We refer as a foreign filing license. What is a foreign filing license? It says that if you are any resident, no Indian resident who wants to file the foreign application, he should get the permission of controller. First one, that is, no Indian resident shall file foreign application without controller permission. This is the first parameter. You cannot go out unless there is a permission. Now I am making out of this, I am making another exceptions. When you will not need the controller permission, when you will not need the foreign filing license. First is, if you have filed in India and 6 weeks have not passed. You have filed in India, but 6 weeks have not passed. If you have not passed, then you need a foreign filing license. Or there is a secrecy direction existing, then obviously you need it. But three conditions if it meets. For example, you have filed in India and 6 weeks have passed and there is no secrecy direction under section 35 exists. Secrecy direction is the direction given under section 35 relate to the inventions which relate to the defense sector. So if there is a secrecy direction that your patent application should be kept secret, that time you cannot file in foreign countries. Okay. Now, this is how it is. Thus, FFL is required for Indian resident. If no Indian application is preferred, you are not filing, but you are filing outside, go for foreign filing license, because it says no Indian resident shall file foreign application without controller permission. There will be a confusion, so I'm just reading the main class. No person resident in India. Let's forget this. Okay, for time being, while reading, make or cause to be made any application outside India for grant of patent for an invention. So no person of resident in India should go for foreign application, except under the authority of written permission, that is the foreign filing license, in the manner prescribed and granted by the controller. So this is, then I'm saying exception is an application in India is fine and 6 weeks have also passed, not less than 6 weeks before the application outside. If the situation where you don't need is, first, suppose you are an Indian resident and you are filing in India. You have to wait for 6 weeks and there is no secrecy direction. You don't need controller's permission, no need FFL. You can go and file in foreign jurisdiction. Okay. Now, just looking, if you are an Indian resident, then only foreign filing license is required. If you are not an Indian resident, you don't need it. Then comes filing in India. Yes, you are filing in India, you are not filing in India. Then you have to go for FFL. If you are filing in India and 6 weeks have not expired. If it has expired, then we will look for something else. If it has not expired, you are saying no, it has not expired. If it is not expired, go for foreign filing license. Then suppose again you are coming to your branches, 6 weeks has expired, but secrecy direction exists. If secrecy direction is again, go for FFL. If they say, then only you will be able to go. Okay. Now, this is the simple FFL requirement, how it will work in various scenarios. Now comes where to file. Where to file is very important. At present, we said applicant part. We understood who is applicant, how he will approach, but who should approach. Then we are saying that you have to approach the patent office. Let's understand patent office structure. The patent system in India is administered under Controller General of Patent Design and Trademark. So the Controller General, the word general says that he is more than he is important for more than one thing. So there is a Controller General of Patent Design and Trade. Now, CGPDTM, he is the boss, and he is appointed under Trademark Act Section 3. Because he is the Controller General of Trademark, so under this he is appointed, but he is also important for the patent and design. So that's the office of CGPDTM is a subordinate office to DPIIT and under Ministry of Commerce and Industry. This we have already discussed. Now, the Controller General's headquarters is in Mumbai. Please remember this. There is a difference. Controller General's headquarters is located in Mumbai. That means CGPDTM sits in Mumbai. But India has 4 patent offices and the head office is Kolkata. If I am talking about what is the head office of patents, then you have to write it is situated in Kolkata. However, if I am asking the headquarters of Controller General, then it is in Mumbai. There are 4 patent offices in India. The head office is at Kolkata, and other patent offices are located at Chennai, Delhi, and Mumbai. So we have total 4 patent offices. Now, patent offices will have territorial jurisdiction. Territorial jurisdiction means which territory comes under them. So Mumbai talks about Gujarat, Maharashtra, Madhya Pradesh, Goa, Chhattisgarh, UT. Please remember this territorial jurisdiction. The reason is you can always expect a question where you will approach. So state of Maharashtra, Madhya Pradesh, Goa, Chhattisgarh, and UT of Daman Diu and Dadra and Nagar Haveli is in Mumbai. Then we go for Delhi. Delhi talks about go to up till Rajasthan ka. Haryana, Himachal Pradesh, Punjab, Rajasthan, Uttar Pradesh, Uttarakhand, and city of Delhi, and UT of Chandigarh, Jammu and Kashmir, and Ladakh. Now, Chennai will talk about the southern states, which is Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Telangana, and UT of Pondicherry and Lakshadweep. Kolkata will talk about rest of India. That is Bihar, Jharkhand, Odisha, West Bengal, Sikkim, Assam, Meghalaya, Manipur, Tripura, Nagaland, Arunachal Pradesh, and UT of Andaman and Nicobar Island. Now, just to emphasize it, I will just this will not be visible. Let's go for this. Okay. Let's start with one. Okay. Now, see. What happened? Okay. This part is Karnataka, Andhra Pradesh, Telangana, Andhra Pradesh. This you do, and then you focus on down. Okay. Kerala, this, and then what I'm talking about, Pondicherry and then I'm talking about this part, Lakshadweep and Pondicherry, right? Okay, it's not helping here. Okay. I think it's not. Let me draw it. That's it. Can I draw? Sorry. ये कहाँ से है? It's not helping. The pen is not working. Anyways, I will share this map, drawn map, just for your reference. Just see. If you are in Jammu Kashmir, Ladakh, this, and this area from here, from this border to this, and you don't have to cross the Bihar border. You don't have to enter in Bihar. This much is the jurisdiction of Delhi, right? Then Gujarat, MP, Chhattisgarh, Maharashtra, and then Goa. Then Dadra and Nagar Haveli, which is on the border of Gujarat, right? यहाँ पर, right? This Gujarat, Maharashtra, यहाँ पर है. So this entire part is of Mumbai jurisdiction. Then we are talking about Chennai, Mumbai, Delhi, and whatever is left will go to Kolkata. Andaman Nicobar will be part of Kolkata. Right. So please remember this, how it will be, and that will be beneficial for you to answer the questions. Now, section 74, rule 4 and rule 5 are important with respect to patent offices and dealing with the patent offices. First is the patent office, and I'm discussing 4 and 5 just for the jurisdiction sake. So for section 74 is very simple. It says there shall be an office which will be known as patent office. Central government will notify the name of the patent office. Then there will be a head office which central government will specify. Head office has been specified as a Kolkata. And for the purpose of facilitating, there can be other places which will be the branch offices of the patent office. So there are 3 other branch offices. And then there will be a seal of patent office, which they will be entitled to affix. So this all comes into 74. So now appropriate office. This is very important, and this determines the jurisdiction of where you are going to file. Please remember, as per the MCQs of 3-mark MCQs can come with respect to these. The first thing is talking about the appropriate office of patent office shall, for all the proceeding under Act, be the head office of patent office or branch office, as the case may be, within whose territorial limit. So he is saying there has to be some address which is falling under the territorial limit. Whose address? Applicant or first mentioned applicant. Suppose more than 2 applicants are there. Then the first mentioned applicant's address will become the basis on which I will decide which territory, which jurisdiction we should go for. Example is simple, that suppose a person is from Delhi, another person is from Chennai. You can choose your patent office if you mention the first mentioned applicant as a Chennai person, then your office, their office will shift to Chennai. However, when it is Delhi, you want Delhi, mention that applicant first, and your office will go to the first mentioned applicant, that is Delhi. So this is how it is. The applicant or first mentioned applicant in case of joint applicant. If you are single applicant, then there is no choice. And what we are looking for? We are looking for where you normally reside, or has his domicile, or has a place of business, or a place from where invention actually originated. So you have 4 grounds: the place of residence, place of domicile, place of business, and the place where actually invention has actually originated, where you have worked on the invention. You can claim, and on basis of that, you will get. Normally, it is the residence address because that's what you have where you will receive the. This is important because there you will receive the service and other things also is received by people. So they normally give their postal address where they are staying. So normal residence. Domicile is different from residence where you have a more permanent nature of residence. For example, you might be belonging to Chennai, you have a permanent address to Chennai, but you are at present you are staying in Mumbai. So you have a domicile of Chennai and you can talk about you can use that. Similarly, registered office of any entity will be considered as domicile. So all you can any company registered office can be the ground on basis of which the appropriate office can be selected when company is the applicant. Then place of business. Company suppose has a registered office, but in Bangalore, but does business mainly in Delhi. So there is a corporate office. So that place of business that address can also be used. And on basis of that, jurisdiction can be decided. And then place of invention is anyway clear. Then comes the applicant for a patent or party in a proceeding if he has no place of business or domicile in India. Then the address for service in India given by such, if suppose there is no place of business or domicile in India. That means it is implied that you do not have a residence also. So now I'm saying that if this applies to foreign applicants. Foreign applicant is not doing business here and he does not have a domicile also in India. That is, he has not migrated to India on a visa. So he does not have a domicile also. If you do not have that, so what should we consider? Then the address of service which will be given by the applicant or the party situated, that will form the basis of defining the territory. Now, what is address for service? We will discuss in Rule 5. What more important is, once I have decided the appropriate office, it will not be changed. Once I have said that this is the appropriate office, the Delhi, you have filed an appropriate office was decided that it will fall under the Delhi or Mumbai. Now it will not be changed. Ordinarily, only in specific circumstances it can be changed. But what specific circumstances is not provided here. Notwithstanding anything contained in sub-rule 2, the controller, that is saying controller can always transfer an application for patent so filed to head office or to any other branch office as the case may be. The controller has the right to transfer any application. So that power is not restricted by the 4.2. Now, then it talks about further application referred in section 16 of the Act. Further application referred to section 16 in the Act is generally understood as a divisional application. The divisional application, he is saying, there is nothing, we are not worried about anything. Divisional application is, let's understand first divisional application. Divisional application, the name says that it is resulting from division of something. So what happens is, there is a rule that every application should have one invention, one application. You cannot have multiple invention in one application. When suppose while examining before the grant, controller is of the view that there is more than one invention claimed in this application. The controller says divide it, let them remove them, divide this, then there will be one, that is the first mentioned application, and then there will be the further application which is the second one which is filed later. So this second application is considered as a divisional application and the first will be considered the first mentioned application. So on what he is saying is, if we are talking about this divisional application, the second application which you are filing, we don't have to worry about it. It cannot go to any other IPO. It will always be filed with the IPO where the first mentioned application was filed, irrespective of any other one. So divisional applications for appropriate office will always be the appropriate office which was decided for the first mentioned application only. Fifth is a transitory for provision, not relevant at present because it talks about that when the Patent Amendment Rule 2/2013 came into existence, at that time, if any divisional application was in different IPO, it will be transferred to the appropriate office where the first mentioned application was existing. Now, as I have told, what is appropriate office? It talks about an application for patent shall be filed. Patent office will provide jurisdiction, territorial jurisdiction will be based on this. Place of residence, domicile, or business of the applicant, first mentioned applicant in case of joint applicant. Place where any mention is absolute. Address for service will be as in India as given by applicant, where applicant has no place for this, that is foreign applicant. Further application, that is divisional application, shall be filed in the appropriate first district. This is the takeaway from this, and then go for change in appropriate office. Not ordinarily change, only controller will have the right who can allocate the application to any other four patent offices as well. Now comes address for service. Address for service, Rule 5 talks about every person. Every person means here that anyone who is approaching the patent office. That includes applicant, opponent, patent agent, everyone concerned in any proceedings to which the act or these rules relate, and every patentee once you have been granted, then you are a patentee. So then every patentee shall furnish to controller an address for service, which will include postal address in India and an email address. These two are the basic requirements. And such address for service shall be treated for all purpose connected with such proceedings or patent as the address of person concerned in the proceeding of the patent. So, what is address for service? Service is that where I will give, send you communications. That is what service means here. That is, suppose I have to communicate with you. Where should I send my communication? I have a letter, I have an email. Where should I send? So you have to tell that address for service. Okay, you give it here and your responsibility ends. That's what it's talking about, postal address as well as email address. Now mobile number is also asked for. Then it talks about unless such an address for service is given. Suppose you have not given any address, then controller does not have any obligation either to proceed or deal with any proceeding or patent or to send any notice. I don't know where to talk to you. Since I don't know, so I have no obligation to do anything with respect to that particular. So unless you provide me address for service, controller is not obliged to even look at it. And controller will have a suo motu decision on that. Suo motu means on its own. So they can decide on their own that, okay, there is no address for service. So whether they have to proceed with it, deal with any proceeding or patent, because they cannot communicate with you. Now, provided that a patent agent shall also require to furnish. Patent agents should provide a mobile number, Indian mobile number to India, so that controller can talk to them. As a patent agent, you receive SMSs of what is happening, any proceeding is there, a hearing is coming. That kind of updates also comes on SMS also. That's so every person concerned in any proceeding of patent office are required to give an address for service, including postal address in India and an email address. Such address for service will be for proceeding on the Patent Act rules, and patent agent must provide mobile number registered. This is what it is. Now we have understood how the patent offices are and what is their jurisdiction. If I'm residing in a particular place, which office I have to approach. Okay. So just a question, because yes, please.
Yeah. Sir, I am just wondering, so why they are not using citizen? So why they are using resident, domicile? that why they are not using the citizen term here?
Citizen is different from the resident. If you are residing in, there can be residents who are not citizen in India. Foreigners are there. For example, in MNCs, various people are staying here. Right. So those are, they are also working here. They are also inventing here. So if you are inventing in India, you are inventing in India, you are a true and first inventor. So you should have, then you, since invention is getting created in India by anyone, they should, the India has a right that that invention should be disclosed. So I'm giving a provision not based on citizen, but as a residence.
Oh,
If I say only citizens of India can get patent in India, then I'm saying any foreigner cannot get the patent in India, or any person who was time being residing in India or any other foreign nationals will not be able to get the India. So now think of it in another way. If you are discriminating in nationals, you are saying you will not get the patent in India. What will happen? The other
reciprocity
party,
relations.
reciprocity, they will say, I will not give to yours. So citizenship is not a criteria.
Yeah, sir, in the second thing, like if I am a citizen of India and I am working in US, so in that time, FFL is necessary if I invent something in US, I am working there as a postdoc.
See, if you are a postdoc, you are not a resident in India. That's why citizenship is a requirement is not here. No? You are not a resident. The moment you are there on a visa, you can claim you have a domicile of US for the time being. Or you can always say that I am resident of, if you have completed 180 days, you will be considered resident of US. So either way, you have invented something there. So under the provisions of residence and domicile, you have the right there. Now you are not an Indian resident. Since you are not an Indian resident, foreign filing license is not required.
But I am domiciled from India, sir.
See,
But my
the section does
domicile.
not talk about domicile.
Oh,
Section talks about Indian resident only.
Oh, okay. So as soon as I
He
left
says
India.
no person resident in India. It's not talking about domicile.
Okay. I got it. So as soon as I leave India for 180 days, then I don't need anything from here.
No. What I am saying is,
Mm.
if you are qualifying for as a no person resident in India, that is considered that you have continuous, you have not stayed in India for more than 180 days. Right.
Okay. Yes.
So that means you immediately go to, for example, suppose you went to US, right, today. So
Yes.
you are still staying in India for last 365 days, no? So
Yes.
you are resident of India. That limit has to cross. Then only this 39 application will not fall.
Okay. Okay, sir. I got it.
Please remember the criteria of resident citizen previous year. It's not in the present year. It talks about the financial, there is no criteria prescribed in the Patent Act. Under Income Tax Act, that's how you are, because income tax is also levied on residence basis. Whosoever is resident in India has to pay.
Okay.
Right. Otherwise, income tax, how will you take? Otherwise, the foreigners who are working, they will not pay income tax. So residence is the criteria, and residence says the person who is ordinarily resident, who is a resident of India. In general, they are very simple definition is in the last FY, if they were resident of India, they have stayed in India for more than 180 days, they will be considered a resident of India and we will tax.
Okay.
So immediately you have gone will not work. It has to be in entire almost a year की उस year में आपको prove करना पड़ेगा पीछे वाले में नहीं रहा. In last year, I was not no more. I have not stayed in India for more than 180 days. Then yes, I'm not a. That's all. Okay. Now comes applications or patents. Then comes form. How to file. So application for patent. I have 750. Let's not go to form of application. I'm not discussing it. It will take time to understand. I will just browse through the types of application for ease of reference. Okay. So let's go to this. There are three main types of applications. Three main types of application. One is simple. You have directly approached the Indian Patent Office. You are not claiming any priority. This is considered as an ordinary application. Then there is, you have again filed in IPO based on an earlier patent application in a convention country. That will be considered as a convention application. Then third is the PCT route. Under PCT route, you have decided, you have filed, you are coming to India in phase, you have filed a PCT application and you have chosen that IP or IB as a receiving office. That my patent should be examined in the territory of India. Then this is the international application, the PCT application which has been filed, and the national application which will be filed here will be the PCT NP phase. Right. So this is the third ordinary convention PCT NP phase. This is the third one. Now, then there are two other kinds, and these are based on the subject matter. First is the how your first three are based on who is receiving the office and whether priority is being claimed or not. The ordinary application, no priority claim, directly in Indian Patent Office, Section 7 application we are talking about. But it is have written section application, but is done ordinary application. Section application, 7 application, PCT national phase will also be considered as Section 7 application. Deemed to be. So we are not discussing at present. Ordinary, convention, and PCT. Focus on this. The ordinary application directly in the Indian Patent Office without claiming a priority, ordinary application. Convention countries, that is mainly is related to the Paris Convention. If you are a member country of the Paris Convention, you are claiming priority from that convention countries. Yes. PCT national phase application is application received from international application or PCT application. Application received. This is the PCT national phase. These are the three. Now subject matter wise. As I have explained, divisional application of application which has been divided into two. The further application is considered as a divisional application, and the earlier application is considered as a first mentioned patent application. Remember this terminology, because in convention application you will use the terminology base application. Here you are using the first mentioned patent application, and division is further application. Then patent of addition is a different patent application which is focused on only an improvement or modification of an invention. That means either that invention has already been applied for or the patent has already been granted. That will be considered as a main invention. If you are filing for improvement on a main application invention, it will be considered the patent of addition. So what happens is, on basis of this, there can be 9 types of applications: ordinary, convention, and PCT. And then because of subject matter, ordinary, divisional, and addition. Okay. So this is the 9 combination which can be formed. A PCT NP phase can be 7. There can be a divisional application out of PCT NP, and there can be additional patent filed for PCT NP. So entire gamut becomes like this. And this is a number assigned to them: 1, 2, 3, 4, 5, 6, 7, 8, 9. Okay. So remember it: ordinary, OCP, ODA, 1, 2, and then 1, 2, 3, 4, 5, 6, 7, 8, 9. Why I'm saying this? Because application numbering, this is how it is used. Every application is numbered on the basis of year of file. For example, you are filing in now. Suppose in 2023, it will become 2023. it will read. Okay. Then there will be two more digits. What will be that? Suppose 2023 you have filed. So the first thing will come 2023. First four letter will define the year. Then 2023 jurisdiction. If you have filed in Kolkata, Delhi is 1, Mumbai is 2, Kolkata is 3, Chennai is 4. If I write 1, that means jurisdiction is Delhi. Then I'm talking about 5. That means there is a convention application. This application is a divisional application, but a convention application. That is, a priority is claimed on the basis of an earlier publication in a convention country, and then you will get the number, whatsoever the number is running at that time of patent. That number will be there, and it will be a 6-digit number. So it can be anything. Right. Okay.
Yeah.
Oh, so you are an established inventor, right? Okay.
Yes, sir. Yes, sir.
See, here see 202241023385. So 2022 is the year it has been filed. 4 is the jurisdiction. 1 is the ordinary application. And then 0222338 is the application. The number allotted to it. Now we went to this. Now we can understand what is the application status. See, it's talking about a chemical invention, a system and method for deterring entry of rodents into a vehicle, and then the address is here, on basis of which system. All the applicants, this is how it is. Okay. Applicant is Mercedes Benz. That too foreign, Germany. Okay. Now we go to application status. Let's see.
Things like
You can play with this IPR search in this just for sake of understanding how this application numbers are there, how that is working, and whatever you have studied today, keep patent office address of service, how that is being taken, how the jurisdiction is being decided, that you can look through just for a general. This is so great. See, the request for examination has not been filed. It has been filed, it has been published. Request for examination filed, then it will become RQ filed, then comes under examination and then disposed. You can see all the documents which has been filed here. Okay. See, the agent's name is here, Bangalore KNS Partners. KNS Partner is the agent. Now comes. It's very slow. Okay. So since it's slow, let me show you the entire document which you get as a, suppose you are filing in patent application, what are the documents? Let it open. Before that, let's go. A complete patent journey is like this. First thing is start here, form 2, form 2, form 4 is form 1, place the form 1. This is the form 2 which was filed for this mosquito attractor and killer for indoors. This is the form 2 that is complete specification filed with this. There should be form 1 also. Is that? Form 1 is here. I think I have not downloaded. What happened? Okay, form 1 I will show you later. There is a form 1. What happens is, along with form 1, you have to file the Form 2. Form 2 deals with the provisional specification or complete specification. In this is how it is drafted. Title of invention is provided, applicant is number, preamble of the description, complete specification is provided like this. All this we'll be discussing later on. Then comes summary of invention, and then see, claims are at the last. Figure, and these are the claims. This is the claim. Once you have claim, this was filed, this is the patent agent's name, then abstract, this is how it's done. Now, Form 1, Form 2, and then we are saying after when it was done, you filed, then there will be a FER generated. FER is generated like this. This is the FER generated. The examination report has come. In this examination report, summary of report is like this. What was the claim? This is the total technical report. This most important is this is the prior art they are citing. Okay. And then they are saying inventive step lacks inventive. Obvious in view of teaching of citing. So D1, D2, D3. In reference me, they are saying because of teachings of cited document, there is no inventive step. First thing. Here they are talking novelty 1 to 10, yes. Inventive step 1 to 10, no. Industrial application, yes. So they have found that invention is novel, but there is no inventive step. Then they are talking about in patent, whether claims there is a clarity, they are saying yes. They are definitive, okay, yes. They are supported by diffusion, yes. Scope, yes. So all this is correct. Then they are talking about non-patentability. So they are saying that under section 3, it is barred. That is yes. So it they have raised a section that it is not a patentable subject matter. Now, please see why it is not a patentable subject matter. That's very interesting. See, they are saying statutory non-patentable under the provision of section 3, section 3B. What they are saying, the disclosed apparatus instead apparatus or apparatus used to intend to kill mosquitoes. So they are saying mosquitoes are living being and part of environment. Since you are killing, it is a serious prejudice to animal life and environment. Hence, it should not be patented. Okay. So this is kind of when you get the objection. You cannot say that this is absurd objection. This is the objection which comes. Now you have to defend the section 3. Then various other, these are the technical requirements. They will say about what sufficiency of disclosure, whether that has been properly made or not. The scope, they are saying the scope is not proper. Just check. This should be amended. And then the formal requirement drawings has not been done. This you have failed. Blank space has not been explored. All those things are there. So this is the how FER comes. First examination report has come. What you will do? You will file a response to FER. This is how the FER is being published. Simple response to objection. Whatever objection were raised, they are here defending. They are defending the inventive step here. They will defend non-patentability subject matter. They are defending here, and then other sufficiency of disclosure, scope, everything is there, and this is how the response is created. And then this is the documents which have been provided as a submit. Now they have also asked for the claims, modification of the claim. This is how you submit the marked copy, that here I have made a change, so that your changes are highlighted where the objection is there. First is a marked copy, another is a clean copy. That's how you submit the claim if there is any, this has happened. Once after this he is fine, then he will give you a intimate the grant and this. This is how grant has been, you have been, this is the information of the grant. Right? Mention this, you have been granted and recorded in the register, patent certificate is enclosed, this is this. Now, Once you get this, what will happen is the working statement, which has to be filed regularly, right? This is being filed. Patent or licensee hereby furnishes this. It has not been worked. Research and developments are referred to. This is a license or licensee granted, not applicable. This is how it is. So from 2020, 2019, the grant date was there, and from there, your liability to file the working statement continues. That's how it is done. Okay, so this is how complete life cycle which we have studied is reflected here. And you can always, this is the form 1, application for the patent. So this is how form 1 is. See, now we have discussed type of application. See, ordinary, convention, PCT, and P. You have to click one, and every phase has divisional patent, divisional patent, divisional patent. If you are not clicking it, it will be considered as ordinary. Okay. Then this is how, if you are going for a PCT, say divisional application. If your PCT national phase, you have to fill it. If you're calling a priority on basis of a convention country, this is how you claim. Then patent of edition, separate, main application and data filing of main application. So this is how, in general, this form 1 will look. We will discuss the form 1 and other in the next class, where I will be discussing this entire document set with section 7. Focus will be on section 7 because section 7 talks about what is the form of application and what are the documents going through should be submitted. And then there will be a requirement under section 8. Section 8. To form section 7 and section 8, most probably we will be discussing on Friday.
Sir,
Yes.
out of curiosity,
Yes, please.
the grant, the patent that you showed application regarding the mosquito attacker killer, so they gave an objection that it was for the environment and life. So how did they get the patent granted?
See, the simple thing they will claim is that killing mosquito is not a serious prejudice to it. And this, there has to be a balance between human life and mosquitoes. Mosquitoes spread diseases. Hence, this is not a serious prejudice to this. This is for the control. We are not eliminating mosquitoes in total, but what we are saying is the mosquitoes should not be in my residential areas where I am there. Whatever I am saying is not going to eliminate the mosquito as such completely. Right? There is nothing. And second thing is, they already exist. There is also a market where such kind of products are already existing. Such kind of inventions are already existing. Hence, it was never considered as serious. These are the basic line where they will be defending.
Okay, sir.
We will read that also, what they have written.
Okay.
Okay. So stopping the recording.